Welcome to this training session brought to you by the Society of American Archivists, Archivists of Religious Collections section. My name is Charlene Martin. We'll start with a land acknowledgement. We acknowledge that we live and work on the traditional lands of many Indigenous nations. We know that Indigenous peoples have suffered from historical and ongoing injustices and understand as an archival organization that we must work towards sharing historical truths and renew respectful relationships with Indigenous communities. We respect the long-standing relationships that Indigenous nations have to this land as the original caretakers. We are grateful for their stewardship and protection of the water and earth. We pay our respects to elders, past and present. Today's topic is privacy and access restrictions in religious archives. Before I introduce our panelists, let's review the disclaimer. The content in these presentations is for information only and is not legal advice. Our views do not represent the organizations where we work. We do not make any endorsements or guarantees. We are not liable for any loss or damage caused by your use of the content we provide. It is your responsibility to critically evaluate the content provided in the presentation or any accompanying materials. Also, please remember the points below. You will not be able to use your microphone or your video during this session. You can click on the closed captioning button at the bottom of your screen, and under live transcript, please click the enable auto transcription to get closed captioning. There will be a question period after the presentation concludes. You should use your Q&A feature to ask your questions. We will not be able to answer questions in the chat or unmute attendees due to time constraints. Please be respectful in your interactions. We expect you to follow the SAA Code of Conduct. This session will be recorded. Please fill out the short survey after the session ends. We encourage you to join the Society of American Archivists if you are not already a member. We also thank the Congregation of the Sisters of St. Joseph in Canada for hosting this webinar. And now I would like to introduce our panelists. First, Mary Grace Kosta. She is the Congregational Archivist for the Sisters of St. Joseph in Canada. In 2021, she won both the Archives Association of Ontario James J. Tallman Award and the Society of American Archivists Sister Claude Lane OP Memorial Award. She is instrumental in providing archives and museum cataloging internships for students at the University of Western Ontario. She currently chairs the subcommittee and is a steering committee member of the Society of American Archivists, Archivists of Religious Collections section. She is also a member of the joint US-Canada ATOM Users Group and the NDSA Communications and Publications Working Group. Our second panelist of today is Erin Greeno. She recently became the Digital Archive Systems Lead for the United Church of Canada Archives in Toronto. Before that, she was archivist for the Ontario Regional Councils of the United Church of Canada. There, she oversaw the records management and archival programs of 6 regional councils and their congregation and communities of faith. She implemented policy on accessing adoption records from maternity institutions run by the church and worked with the United Church of Canada Archives Network to create a denominational policy of accessing sacramental records. Our third panelist is Claire Wilton, and she has been the Archivist and Privacy Officer of the Anglican Diocese of Toronto Archives for the last 4 years. She was their archives assistant for 8 years before that. Claire provides guidance to Toronto Diocese parishes about providing access to sacramental records and personal information. She holds an MLIS from Western University, is certified with the Canadian Institute of Chartered Accountants, and has a personal interest in genealogy. Our last but not least panelist is Laureen Harder-Gissing. For the last 15 years, Laureen has been the archivist librarian of the Conrad Grebel University College, which is located at the University of Waterloo in Ontario, Canada. She is the administrator of the Library and Mennonite Archives of Ontario and researches and publishes on the history of Mennonites in Canada. She holds degrees in history, religion and culture, library, and archival science. We'll get started with Mary Grace. She's going to start her recorded presentation.
Today I'll talk about how we follow the spirit of the law in our privacy policy and procedures. Legislation varies by jurisdiction, so your practices will be based on where you're located as well as what type of archives you have. I'll mention the privacy laws in Ontario, but only one of these laws actually applies to religious archives in this jurisdiction. In Ontario, the Freedom of Information and Protection of Privacy Act, or FIPA, applies to provincial ministries and agencies, colleges and universities, and municipalities and local boards. Under this legislation, access is not permitted to personal records of an individual without their consent, but is allowed 30 years after the death of the individual. There are some exclusions to access in general, including financial and employment records, and those governed by solicitor-client privilege. Specifically related to archives, records that are privately donated are not covered by this law, and instead, access is governed by the deed of gift. But records concerning donations are subject to the law, along with records concerning donors, researchers, volunteers, and employees. Any personal information collected should be for a stated purpose, provided with consent, and not disclosed. Records containing personal information should be kept according to a records retention and disposal schedule, which complies with legislation. Consent is needed to identify donors and finding aids, and the deed of gift and accession records should not be provided to researchers. It is important to keep track of any personal information banks, for example, volunteer files which contain resumes, volunteer forms, and letters of reference. None of this information should be disclosed. Lastly, all requests for information should be in writing. In Ontario, the Personal Health Information Protection Act, or PHIPA, applies to personal health records under the control of a health information custodian. This includes records related to the provision of health care, organ donation, health number, and substitute decision maker. If these records are held in an archives, PHIPA does apply. Personal health information is protected until 50 years after the death of the individual. It's important to think about the impact of access restrictions when acquiring these types of records. In Canada, the Personal Information Protection and Electronic Documents Act, or PIPEDA, protects personal information collected during the course of commercial activity. It does not apply to nonprofit or charity groups unless they are conducting commercial activities like running a gift shop, and then only in that context. Fundraising is not considered a commercial activity. Under this law, personal information is protected for 100 years after the information was collected or 20 years after the death of the individual. In Ontario, FIPA and PIPEDA do not apply to religious archives. However, we developed our privacy and access rules to reflect the spirit of these laws. The records which contain personal or sensitive information in our archives are records related to living people, records related to volunteers, job applicants, employees, researchers, and donors, photographs of children or hospital patients or people in trouble, like soup kitchen clients, personal files of deceased sisters or those who have withdrawn from the congregation, staff and student records of academic institutions, staff and patient records of healthcare institutions, orphanage records, records naming recipients of donations, financial records, records concerning confidential decision-making, and records restricted by law, such as those containing personal health information. Sometimes the information in these records is useful for genealogists and serious researchers, and so a balance must be struck which follows the spirit of the law. We have a privacy and access policy, and all requests from researchers must be made in writing. Each request is evaluated based on its purpose, who is making the request, and following our policy. All records received by the archives through internal transfer or donation are subject to our privacy and access policy. We put restrictions on some records for specified time periods, and these restrictions may be applied only to members of the public, but are applied equally in all cases. We do not provide access to unprocessed collections. Records which violate the privacy of living people are only released to the named individual to whom they relate, or to their authorized representative, or with the written permission of the named individual. These records are open to the congregational leader or her designate. This applies to academic records as well. Consent via a signed release form is required from living persons depicted in photographs and recordings and in the corresponding captions and transcripts in order to publish or display these. Materials are not published or displayed if they depict children or people in trouble. Identifying information about recipients of donations is not released except to the congregational leader or her designate. Information from orphanage records is only released to the person to whom the records relate or to their authorized representative or with their written permission. If the person is dead, information can be released to their next of kin, but Ontario law prevents the release of identifying information about birth parents. Records that are 100 years old are open to the public. Deceased sisters' personal files are restricted for 2 years after death and open only to the congregational leader or her designate during this time, after which access is provided to family members. However, personal health information is restricted for 50 years after death. Restrictions on other records of deceased sisters may be put in place for 30 years after death if these records are considered sensitive. Records pertaining to confidential decision-making are only disclosed if the decision has been made public or the passage of time means that their release would not impede current decision-making. These records are open to the congregational leader or her designate at all times. Records containing confidential business or financial information are only open to the congregational leader or her designate until the passage of time means there would be no harm to the parties identified. Records donated to the archives may be restricted for a specific period as specified in the deed of gift. Decisions on restrictions are noted in the accession record, and restricted records are noted in the finding aid. Restricted records remain in the record group in which they are arranged, and each file in a series containing restricted records also contains a withdrawal sheet listing the restricted items. Periodic reviews of restrictions takes place, and when restrictions are removed, the withdrawal sheet is also removed from the file. Electronic records that are restricted are stored in a separate space on the computer drive, and metadata indicates the access conditions. We use our own local servers, so don't have to worry about cloud servers located in another country and compliance with the privacy laws of that country. It's a good idea to prioritize the processing of sensitive records and flag those with access restrictions as you work, making sure these records are identified in finding aids. You can improve privacy protection by minimizing the amount of private data you keep and redacting when necessary. Lastly, you can advocate for strong privacy and access protections across your organization by ensuring there is a records management program in place. This both manages risk and encourages openness, transparency, and accountability.
Thank you, Mary Grace. Our next panelist is Erin. Are you ready?
I am, yes. Thank you. The United Church of Canada Archives in Toronto is the official repository for the General Council, which is the national governing body of the United Church and its administrative units. It is also the archives for the 7 Ontario regional councils and the congregations within their boundaries. The 2 archival programs are managed separately, but follow mutual policies and procedures, including privacy and access. Today, I will very briefly discuss some of the record types that are affected by privacy. However, I suspect many of these record types will be mentioned by other panelists. So instead of detailing our policies, I will share some case studies from the United Church Archives when a public issue influenced our approach to balancing privacy and access. So here are some of the record types that we have in our holdings that are restricted for various time periods to protect the personal information that they contain. Sacramental records such as baptismal, marriage, and burial records hold evidential value for genealogists. However, they contain personal information that needs to be protected for those still alive. We also impose restrictions to records relating to personnel, both clergy and lay, including any commissions and hearings of personnel. Exemptions are made for researchers in some cases. However, to gain access to restricted material, they must sign a researcher agreement which details how private information can or cannot be used or shared. I believe most people understand why these restrictions exist. However, religious archives are often unfairly labeled as difficult. We are often seen as fortresses withholding information instead of institutions preserving information to be shared and used. And I'm not going to try to explain why these presumptions exist, but I would like to share two examples where the United Church of Canada Archives responded to public pressure to provide access, and we approached them with privacy in mind. The United Church of Canada for many years operated maternity homes across Canada. These homes provided services to pregnant girls and women who were not married and who were encouraged, if not forced, to give up their babies for adoption. In 2012, advocacy groups representing mothers who gave up their babies for adoption called for a national inquiry into forced adoptions. The United Church was called to respond to their requests. The archives had few records relating to maternity homes, and so it was not a surprise when advocacy groups and the media suggested that the church was hiding information or evidence of forced adoptions and abuse. So we immediately reached out to partners to locate any available records. In 2019, the archives acquired the records of Victor Home, which is a maternity home in Toronto, including client files from 1912 to 1989 and adoption placement records from the 1950s. These records are highly sensitive and contain personal as well as medical information. It would be easy to keep these records closed to protect that information, but we knew that there would be resistance from both birth parents or adopted persons wanting access to their records. We wanted to provide access in the least harmful of ways. So in Ontario, there's the Access to Adoption Records Act, which allows birth parents and adopted children access to their adoption records unless one of the parties filed a disclosure veto with Service Ontario. Once a veto is filed, no one can have access to the full adoption records. The UCC archives wanted to follow the provincial legislation, but the problem was that we don't have access or have record of who filed for disclosure veto, nor would we have the authority to verify that information with Service Ontario. To address this issue, we developed an access to adoption records policy, which allows adult adopted persons, adoptive parents, birth parents, and immediate relatives access to non-identifying information. Files are then redacted to remove any information that could be used to identify one of the individuals, and proof of identity or relationship is required. We also provide access to identifying information to individuals who have successfully applied for adoption records through Service Ontario and who can provide evidence to the archives that the no disclosure veto was registered by the birth parent or adopted adult. Pressure from the advocacy groups forced us to not take the easier approach to such sensitive records, and we were able to find a balance between providing access and respecting privacy that I believe is acceptable to all parties. A second case study involves the records of residential institutions, historically referred to as residential schools. As many of you know, these residential institutions that were run by churches and governments forced Indigenous children from their families, homes, cultures, and languages. As part of the Indian Residential School Settlement Agreement, the United Church of Canada was obligated to submit records relating to the residential schools it ran to the Truth and Reconciliation Commission. There was and continues to be great research interest in these residential institutions, as well as day schools and other colonizing institutions run by the church. Despite public criticism of religious archives during the TRC, we felt we were providing access to records fairly and respectfully. Post-TRC, we began reassessing our practices through a reconciliation framework, including reviewing our access policies. We acknowledge that archival institutions are inherently colonial operations and that archival policies and practices can uphold and reinforce colonial power and privilege. So for instance, we understood that our reading room with our researcher policies and procedures may not provide a comfortable space for Indigenous researchers, especially when dealing with such traumatic material. One approach that we took was including that was the creation of community packages of digitized records to give to Indigenous communities to support their own research. Some of the records would be restricted, but contain important evidence. To be transparent, we do include the restricted material, but ask that they be treated like any personal or private information should. We also had to reassess how others were accessing the records. From community feedback, we acknowledged that many researchers were studying Indigenous communities, but never approaching the communities that they were researching. This perpetuates the continual othering of Indigenous peoples. So we are implementing an ethical research policy to encourage consent and collaboration. The work was done by our colleague in BC in consultation with Indigenous leaders. While still in the initial phases of implementation, the ethical research and protection of Indigenous interest policy attempts to give Indigenous peoples more control of how their records or records relating to their communities are being used. Researchers will be encouraged to consult with Indigenous individuals or communities to determine whether Indigenous peoples have an interest in the research. We will ask researchers to provide a statement of support from communities to ensure the community or individuals have consented to the access of the records. And the researcher will need to agree to not exploit the information and seek consent from Indigenous peoples before publishing. This approach to access complies with the First Nation principles of OCAP, which states that Indigenous peoples should control their information. In many ways, this approach to research and access reflects some common donor restrictions, but we're applying it to communities. Public issues have forced us to look at privacy and access in new and sometimes challenging ways. We accept these challenges as we are always looking to prove access to records, and I welcome conversations on balancing access and privacy. Thank you.
Thank you, Erin. And our next panelist is Claire.
So I'm Claire Wilton. I'm the Archivist and Privacy Officer at the Diocese of Toronto Archives, and we collect records for the diocese as well as for the parishes and congregations that are in the Diocese of Toronto. So in terms of privacy at the Anglican Diocese of Toronto, as mentioned by Mary Grace earlier, not all archives are governed by the same privacy legislation or any legislation at all. As a not-for-profit that is not engaged in commercial activities in the province of Ontario in Canada, the Diocese of Toronto is not technically governed by any privacy legislation. However, when the Canadian Personal Information Protection and Electronic Document Act, PIPEDA, was enacted, the diocese made the decision to develop a privacy standards policy. It was felt that it would be a good idea to follow the guidance set out in the Act to ensure we would be in compliance should all not-for-profits be added to the legislation. Several years ago, it was determined that the archivist should become part of the diocesan leadership team, and that now means that we provide information on privacy to new staff, new parish clergy, and new parish leadership. In the case of the Anglican Diocese, the parish leadership is the priests and the church wardens. The diocese currently has a policy on access to parish and diocesan records, which was last updated in 2019 and will be revised in the coming year. We're working to make our holdings more accessible through online finding aids to encourage academic researchers to use our archives. As a result, it's important for us to have more detailed access policy to ensure that researchers are aware of restrictions and ensure that access restrictions are applied equally to everyone. The majority of researchers who access our archives are genealogists conducting genealogical research. As a result, the restriction we deal with on a regular basis is access to our vital statistics records, including baptisms and marriages. We follow the Archives of Ontario access restrictions for vital statistics to births and marriages, with baptism records closed for a period of 104 years from date of birth, and marriage records closed for 80 years. For vital records that are closed to public access, we release the record to the individual named in the record, and parents in the case of baptism, next of kin or power of attorney, and we require proof of ID. In cases like this, a member of the archives team would access the record and make a copy or provide the information. While we have specific access policies stated for these most frequently accessed records, there are other records in our archives that have access restrictions due to sensitive or personal information. These include, but are not limited to, bishops' papers, which may include notes from meetings with clergy, and personal diaries, which may contain sensitive or personal information about someone else. Clergy personnel files, which may contain sensitive information about pay, health, or discipline. Committees that deal with confidential information, such as the HR committee or the bishop's court. Parish membership lists, which include donation information or contact information. However, even within some of our seemingly benign record series, there may be personal information that is interspersed. As we are working with records and come across these items that should have restricted access, we will update accession records to note this. The archives team makes every effort to determine access restrictions while processing accessions and making note of those restrictions on the accession record. But sometimes they can be missed when processing a large transfer and accession of material. While no specific legislation governs the Diocese of Toronto archives, we do use existing legislation in Ontario and Canada to provide guidance about access restrictions. Access restrictions that apply to personal records in the province of Ontario that fall under either the provincial legislation, the Freedom of Information and Protection of Privacy Act, or the federal legislation, the Personal Information of Protection and Electronic Documents Act, range from 20 to 30 years after death of the individual, or between 100 years and 120 years from the date the information was collected, if the date of death is not known. We tend to err toward longer periods of restricted access, particularly for personnel files. In addition to the legislation, regular discussion about access restrictions with the leadership team help to determine the access restrictions. We do have to be particularly careful about access to bishops' papers that may contain information about other people, as the access period would relate to the individual named rather than the bishop. We currently provide access to closed records to the bishop and the bishops and their designate for records that have restricted access. For parish records with restrictions, we do allow access to the corporation of the particular parish, which includes the priest and the church wardens. Ultimately, these are their records, but in the custody of the diocesan archives. For academic research, we may allow access to restricted records after the researcher has submitted a written research request to the archivist and completed a research agreement. The research agreement sets out the responsibility regarding the access to and use of personal information. Primarily that the researcher will not identify in any public way personal information about persons mentioned in the records, and that no personal information will be used or disclosed in a form in which the individual to whom it relates can be identified. We have recently had some queries from congregations about parish nurse records, as several congregations have parish nurses who provide care to those in need in the local community. So I thought it would be worth sharing that information here. Due to the Personal Health Information Protection Act of Ontario, which is provincial legislation related to personal health information, we don't accept patient records kept by a parish nurse. These records should remain with the health information custodian, which is in this case is the healthcare provider. And we ask our congregations to ensure that any such records that are kept on site for access by the parish nurse be kept in a locked cabinet only accessible to the parish nurse. So thank you very much, and on to the next presenter.
Thank you for that. And we'll go on to our last but not least. Laureen, are you ready?
Thank you, and hello, everyone. I will begin by just giving a brief introduction to who we are and where we are. So Conrad Grebel University College is a Mennonite college affiliated with the University of Waterloo. So all of our students are University of Waterloo students. All of our courses are University of Waterloo courses. But our college was started by Mennonites and has many aspects of its Mennonite character still after 60 years. The Mennonite Archives of Ontario is located within the library of Conrad Grebel University College. And the archive serves as the repository not only for the college, but for Mennonite organizations, congregations, families, individuals with roots or branches in Ontario. So we're not only denominational archives or a college archives or a religious archives, but in many ways we are also a cultural and community archives. Our privacy and access policies are governed by our access guideline. And as others have mentioned who are somehow connected to academic institutions or public institutions, some of our records are governed by FIPA. So in our case, the records of Conrad Grebel University College are governed by FIPA. Our guideline as a whole is informed by the International Council of Archives principles of access to archives. So there is a template and several other documents that you can find on their website. And long before my time, when our access guideline was first drawn up, we used those guidelines as a template. Basically, the template divides restrictions into either general or specific restrictions. General restrictions apply to types of information no matter where they can be found. For example, social insurance numbers, it doesn't matter where they're found in any collection, they're all the type of information that is obviously confidential. Specific restrictions relate to specific donors or specific collections. And this template provides for a process for accessing restricted information, and it aims to create, as we have heard many of us say so far today, a balance between privacy and access. I thought today, rather than going through our policy, I would share a couple of examples of how it all sounds very nice and neat to talk about privacy and policies and access, but it's often more an art than a science, especially when you get into the life of a community, the life of individuals. So I thought I'd share a couple of examples of balancing privacy and access in the context of our Mennonite history and community, and hopefully that will have some wider applications as well. So what you're looking at here is a chart I created a few years ago for a group of Mennonite archives as we were trying to have a conversation about when to post photographs on our online database, the Mennonite Archival Information Database. What I did is I took a very excellent section from the book Photographs, Archival Care and Management, as you see cited there, and created an outline with a continuum from a lesser expectation of privacy to a greater expectation to help us think about the decisions we need to make. So in our archives, we have a series about a dozen photographs of a location called the Clearwater Lake Sanatorium in the Pas, Manitoba. Unlike the example here, most of the photographs in that series show Indigenous children as patients in a medical setting in the sanatorium. These were taken by Mennonite nurses who were volunteers in the 1950s at Clearwater Lake. So if we can just go back to our chart for a minute, based on these kinds of criteria, we would probably not consider posting these photographs. The photographs are only from the 1950s, so therefore, more than likely than not, it's living persons we're dealing with. These are vulnerable persons in a medical setting, and so on. It seems pretty clear that there should be a greater expectation of privacy around these photographs. However, a few years ago, I was contacted by an Indigenous research project into Indian hospitals, and they were very much interested in uncovering the lived experiences of these hospital patients. Through my conversation with them, it became clear that our photographs could provide valuable information for their project and also to serve the purposes of truth and reconciliation. So we did end up posting the photographs on our photo database, the Mennonite Archival Information Database. And we also donated copies to the project, the Manitoba Indigenous Tuberculosis History Project, and they have posted some of those photos as well on their site and contextualized them in their own way. In order to provide some transparency about why these photographs appeared on our site, I created archival note in our metadata. And in case you can't read it there, I'll just read it for you quickly. These photographs include images of patients at Clearwater Lake Sanatorium, which was part of the racially segregated Indian hospital system in Canada. The Mennonite Archives of Ontario has chosen to display and describe these photos in order to contribute to knowledge about these institutions and to the First Nations and Inuit people who experienced them. If you have any information about this photograph or questions about our use of them, please contact us. There's also a separate little note that indicates the participation of the Indigenous Tuberculosis History Project in the decision to publish these photographs. So that is an example where we took something that would seem to be very restrictive on the face of it and made them more public. Here is an example of where we have pulled back and made something more restrictive. So this example comes from a family collection. And for much of the 20th century, it's a problem with being an archivist, you forget which century you're talking about. For most of the 20th century, Mennonites in Canada with relatives in the Soviet Union were separated by war and then the Cold War. I often receive Canadian Mennonite family collections that contain precious letters received from Soviet relatives. In one of these collections, an elderly Soviet Mennonite woman writing from the Soviet Union wrote her life story through a series of letters. It's a remarkable story, and it's one she kept secret from her husband and children because she hid her Mennonite identity from her family and from the rest of society for decades in order, she felt that's what she needed to do to survive. While the woman has been deceased for nearly 20 years now, I decided to restrict access until 100 years after the birth of her youngest child. In our inventory, her Mennonite birth name is listed, but her assumed Russian name can only be discovered by accessing the file, which can only be done by a formal application to the archives. This longer restriction was applied to honor a wish she had expressed to her Canadian cousins during her lifetime that her family not know her true heritage in order to protect her and them from unforeseen consequences. Yet, even though that restriction is fairly long-lasting, there is still a door open for future access and discovery of her story. So finding these types of balances can be a time-consuming process requiring thought, close readings of materials, and consultations. But sometimes this is what is necessary to find that elusive balance between privacy and access. Thank you.
Thank you, Laureen. And now we're going to open up the Q&A. We've got some really interesting questions. We may not be able to get to them all because of time constraints, but I'm just going to provide this question for all of our panelists and somebody can go ahead and answer. The first one is, can the adoption veto be appealed? what is Service Ontario? And I think this might be regarding the first presentation or the second.
Yeah, that was actually in reference, I think, to our adoption policy. So Service Ontario, sorry, that was, I should have been more explicit as to what that was, but it's an agency that runs a lot of the vital stats of Ontario, but including managing adoptions. And so as a government agency, we're not able to access who has disclosure veto. But when we were going through the legislation, it did seem to me that that is not, the disclosure of veto wasn't something that could be appealed. And that basically it was just one of the parties, whether it was the birth mother or the adopted adult, wanted to make sure that no one knew of their story. And so they have basically said that no one can access those records. So it's a good question as to whether or not they'll be open at any point, but I'm assuming it would be after a particular retention period of 100 years or so.
Thank you. The next question is, someone said they're very interested in the ethical research policy to better share ownership of records that take Indigenous ancestors as their subject. They wanted to know if it's available online, if there's policy available.
We are actually still working on the kind of the logistics of the policy and wanting to make sure that we are representing the best interests of the Indigenous communities. And so it's not available on our website as of right now, but we do have a section about our anti-oppressive work and our reconciliation framework, and it would be there at some point.
Thank you. And let's see, we've got another question about collecting records from closed or closing churches. Also, too, about collecting records from active churches.
We collect from both closed and active churches.
Do you want to expand upon maybe your process, your procedure?
So
policies.
So for active churches, we recommend particularly for parish registers that they come to us as soon as they're completed, or if they are older than 50 years. So just to try and get them in a safe place. We have a fire suppression system in our vault, and it just sort of ensures that we have access. Having recently had to go to great lengths to try and recover a register that had been misplaced at a church. I went in and helped move 13 boxes, and we finally located it. We're kind of really going to be pushing that. And then we take any other records that an active church wants to pass along to us if they need to free up space. And then we take all closed church records after review to determine what should be kept permanently.
Yes, that's certainly the case for us as well. It's especially moving to be part of a situation where a church is closing, and there's a sense of at least somehow their story will carry on by coming to an archive. So it can be a bit of an emotional time.
When it comes to the sacramental registers, are you applying the policies that we've already discussed during this panel session, or do you sometimes customize them based on what the church staff are requesting for their particular sacramental registers?
I can try to answer what we do at the United Church. So we actually encourage our communities of faith, or what would be called parishes elsewhere, to kind of follow the same privacy legislation as, or privacy restrictions as we do at the archives, because we consider these records to be sacred, and that people gave their information in trust to us as a denomination, and that we shouldn't abuse that. But obviously there's been many cases where organizations have reached out to congregations asking for access to their registers so that they could be made available for research purposes or genealogical purposes. And we try to encourage congregations not to do that because of privacy. And we do that ourselves at the archives. We have made exceptions. There's been projects where, where researchers have been studying, medical histories or health histories of communities. And so we've allowed access to our registers for those types of research with an understanding that they would not be using the personal information.
Thank you. Now, let's see, we've got some interesting questions regarding personal correspondence. There's a question about whether or not it's automatically restricted for a given time period, or if it must be considered sensitive in nature to be deemed a candidate for restriction. So in other words, reading through it and then evaluating it. Anybody want to answer that one?
We would probably do a quick review of the contents before determining whether it could be accessed or if there needed to be some restrictions on what could be viewed. But generally speaking, if it's what we would call miscellaneous correspondence, then generally it would be open. If it was personal, we would want to review.
This might be related. What criteria does the Diocese of Toronto use to determine what, if any, bishop papers you grant access to researchers? In this case, it's just general. They didn't specify whether it was personal papers or administration.
So it would depend. Yeah.
Gotcha. All right. Let's see. A question for Laureen. What was the reasons to restrict the Soviet Mennonite woman's records for 100 years from the youngest child's birth? I think you kind of answered that in your presentation, but if you wanted to elaborate.
That's okay. I know I went through that pretty quickly. Yes. So the family had lost contact between Canada and the Soviet families had lost contact with each other in the past 15 years or so. So there was no way to go and ascertain kind of how the Soviet end of the family would want to approach that. So we erred on the side of caution. We knew that the woman before her death had spoken to her Canadian cousin and said, we want, I don't want my children, not only to not, it wasn't only a matter of not knowing, but a matter of somehow this becoming compromising information that someone could use against them, that they are of German Mennonite parentage, that she, because of her many life experiences, did not want that to happen. So in order to kind of respect her wishes, and not having any contact with the Soviet end of the family, I went with a restriction of 100 years following the birth of her youngest child.
Thank you. That makes sense. There's an earlier question. Somebody was interested in the ethical research policy to better share ownership of records. Oh, I think we already talked about this. To take Indigenous ancestors as their subject. Is that available online? I'm not sure if we already asked this question. We did. Okay, sorry about that. Next question, what did community packages to the Indigenous communities contain? And Erin, this might be regarding your presentation again. Records pertaining to their history, equipment and technology that they could use to research and provide access on their terms. Somebody was just asking what the contents were out of curiosity.
Yeah, so as part of the TRC document collection, we digitized all records relating to the residential schools. And then in addition to that, we have started a long-term project of digitizing all records relating to Indigenous peoples in our holdings. So that could be congregations, missions, hospitals, day schools, residential schools, etc. So as we go through that, we are organizing it to be able to give that digitized material to communities when asked. And so what we do is we put all of the digitized image scans into external hard drives, and then we send them to the communities so that they could use the records as they wish. and to do their own research. Too often, there's this expectation of others having to do the research for Indigenous communities because of the distance. We're in Toronto. There's other circumstances too where people might not want to visit the archives. And so we wanted them to be able to have access to the records and to have them to be able to use at their own will, per se, yeah.
Thank you. There's another question, and this is going to be a quick one, I hope. You mentioned the custody of archives as sacred, and this could be any one of you. Can you expand upon that?
I think I said that in terms of the sacramental registers. And the reason why we were thinking about it is that for many, it's just information. It can be used for genealogy or other purposes. But the church wanted to acknowledge that these moments in time, people put sacred trust in the church to protect their information and not to use it for other purposes. And so I think that's the only time I really refer to the records as sacred, and because of that relationship between the moment that's being documented and the information that's recorded.
Thank you. Let's see if we have time. We don't have a lot, but we have like maybe 3 more minutes for who evaluates and makes decisions granting research requests for access to restricted materials in your archive? Is it up to the discretion of the archivist, or is there a designated group or a more formal process?
In my case, it's the archivist, which is myself, and if I should deny that, then the appeal would be, since we're an academic institution, the appeal would be to our dean.
And it's the same in our archives. It's the archival staff that makes those decisions about whether records should be restricted, and they are the ones that insert the withdrawal sheets at the file level for restricted records.
Yeah, I just wanted to add, for us, it's the same. It's archive staff, but when it does deal with records of Indigenous peoples, if it's not something that we've already had to deal with, we then consult the Indigenous Ministries and Justice unit of the United Church for guidance, and if need be, then we reach out to communities to get their feedback as well.
And for the diocese, it's the archivist, and if there's any further concern after that, it would go to the bishop.
Thank you. This has been a great discussion, and I know there's more questions, but we have to wrap it up for now. So thank you, everybody. I wanted to also mention to all of our attendees that we also have 2 more sessions that are coming up in this calendar month. We have an archival chat February 22nd at 3 o'clock, community archiving with Anglican parishes. We also have one on February 29th at 3 p.m., discovering enslavement histories in Catholic Church records. So both of those are very interesting topics too. We hope you all can attend. Thank you.